Hello, this is Sigmund Collins, and today I want to talk about a question that often comes up when clients start the estate planning process. And the question is this: does a will control the passing of any assets I might own at the time of death? And the answer to that question is no. A will only controls the passing of assets that are in what's known as your probate estate. The probate estate is everything you own that does not pass by either contract or by operation of law. It's a very important distinction. So let's look at a real life example of how this works and how it plays out so that you can be well equipped when you start your process of creating an estate plan. So Bob creates a will, and in his will, he says, I leave my $1 million life insurance policy to my 3 children in equal shares. He names his oldest daughter to be the executor of the will, and he makes her the beneficiary on the life insurance policy. The thinking there is that the money will be paid out and she'll split it with her siblings according to the will. Well, Bob passes away. Who gets that payout from the life insurance company? The answer is whoever's listed on the beneficiary line. In this case, it's the oldest daughter. Well, maybe you guessed that already. But now the will says that that money's supposed to be divided up among the 3 children. Does she have to do that? No, she doesn't have to do that. That life insurance policy and that money is a non-probate asset. Why? Because the insurance policy is a contract between the insured, the policyholder, and the insurance company. So it's paid out not according to the will, it's paid out according to the beneficiary designation. Now, wait a minute. I just told you that the oldest daughter was named as the executor. Isn't an executor bound legally to carry out the requirements of the will? Well, yes, except in this case, not only does the will not have power over the life insurance, it doesn't have power over the beneficiary of the life insurance. So even though she's named as executor, she is not compelled legally to share that money with her siblings. And in this case, she chose not to do that. And there was nothing the children could do. What Bob should have done was to create a trust so that his life insurance could be paid into the trust, and then the trustee could have distributed that money according to his wishes to his 3 children in equal shares. But by simply writing in the will that you want your life insurance to be shared is not going to get the job done. The sister in this case, the oldest daughter, once she realized that there was no legal obligation to share the money, she did not. Well, as you can imagine, family gatherings were probably a little bit awkward from that point forward. So don't let that happen to you. You have to know the difference between probate and non-probate assets. That's why it's important to let your attorney know everything that you own so that the plan can properly reflect what you have and how to pass it according to your wishes. All right, I hope this has been helpful. Thanks for watching as always, and God bless.